I'm very happy to be moderating our next panel. Is the GDPR ready to meet the challenges of AI? That is the question, as Elena said, for our next panel. Artificial intelligence is rapidly transforming our economies and societies. And it also challenges the way we think about data protection. The GDPR, as a technology-neutral regulation, has set global standards over the past years. But today, the pressing question is the GDPR fit for purpose in the age of AI? Or do we need new rules, clearer guidance, and new models of governance? In this session, we want to explore three key questions. Where do we see the limits of GDPR when it comes to AI? How does the AI complement or possibly collide with the GDPR? And finally, what are the practical challenges that companies face, and how can policymakers and regulators provide the right incentives to align innovation with privacy? I am delighted to welcome three excellent panelists to our discussion today. I think one panelist hasn't arrived yet, but we will start with the two, and hopefully Karolina will make it. First, I want to welcome Bojana Bellamy. She's president of Hunton's Center for Information Policy Leadership, a global privacy and data policy think tank located in Washington, London, and Brussels. At CIPL, Bojana works with global businesses and technology leaders, regulators, policy, and lawmakers to shape global data policy and practice, and develop through leadership and best practices for responsible and trusted use of data and technology in the fourth industrial revolution. Bojana, I'm very happy that you're here today. Next, I'm happy that Dr. Marek Steffen Jansen is here with us today as well. He is Director of AI and Privacy Strategy at the Volkswagen Group, working at the intersection of regulation, software, and innovation governance. As a qualified lawyer, he advises on strategic questions around privacy, AI, and digital policy. Before joining the Volkswagen Group, he held positions at Google, the Federation of German Industries, the German Parliament, and co-founded his own software startup. Marek, we're also very happy that you're here today.
Thanks for having me.
Perfect. So I still don't see Karolina. We would be very happy if she can join us, but I think she has some technical issues at the moment, but that's not too bad. We'll just start, and if she tunes in, then we'll just jump right to her. So I'm very happy that the two of you at least have no technical issues, and we can start with the discussion. I would maybe start with an introductory question to you both. And when you both think about AI and data protection, what is currently the biggest open question or maybe uncertainty that comes to your mind when you think about that? Bojana, maybe you want to start.
And Isabel, thank you so much for the introduction, and really it's great to be everybody. Thanks Bitkom for organizing this important meeting. So much interesting, so many interesting panels as well. I wish we really were together live and be able to also talk at the margins. But your question is very important. Look, I think the first thing to say is that data is the most important element of AI. And as much as GDPR obviously regulates the use of personal data, one of the things is it has to be that we need to understand what role that data plays in development, deployment, and use and adoption of AI technologies. And so when we have that mindset, I think there are really two, probably I would say, open questions and legal uncertainties. One, it's on legal basis. For use of personal data, and particularly, dare I say, sensitive data for development, training, and deployment of AI. And I think secondly, I sort of, I had a little bit of a context here. Shall I say data minimization, purpose limitation? But I think, let me leave that for later. I think how the individual's rights interact with technology is going to be really interesting, right? What does it mean, the right to object to the use of data in LLM or deployment? What does it mean to have right of access to personal data? Which brings us to, is there personal data in the system, where it is, what is possible? A little bit like the blockchain conversation, where the right to deletion, right to be forgotten doesn't really exist in blockchain. So I would say these are the two key open questions, but there are more to be discussed, certainly.
Yeah, thank you very much. Maybe Marek, you want to jump right into there.
Yes, absolutely. And thank you, Isabel, for the nice introduction and also having me. Actually, I can echo what Bojana just said, but just let me add something that comes to my mind. So I think when we talk about AI and data protection in Europe, one important unresolved question is whether we can truly operationalize the GDPR's risk-based approach without drifting into what I would say like a de facto zero risk standard. So in practice, I feel that many debates and also interpretations treat the GDPR and overall data protection as like an ultimate super right. So, overriding other fundamental rights and legitimate interests, such as safety or general innovation. And in our industry, automotive, we work with rather long development cycles, and we depend on legal certainty to make those investments. And when different DPAs read the same GDPR articles differently, and in some cases, to be honest, we are also dealing with interpretations and guidelines that miss technical and even like economic reality. And the result from an industry perspective is hesitation and also delay, right? And the dynamic shows up in AI life cycles, to underline what Bojana just said, how purpose limitation applies when general purpose AI models are improved over time, right? Or what lawful bases are appropriate for the processing of personal data, for the development and continuous improvement of these models, how transparency and data subject rights are made meaningful when there isn't a person index storage of data, right? All these questions. And so there is like this persistent legal uncertainty born from this, I would say, lack of shared framework to translate these essential goals of the GDPR into a language that companies can build upon. And on the other side, also the regulators can enforce at scale. And last point I would just stress is that the conversation about AI and privacy should not be framed as a choice between fundamental rights on the one hand and innovation or technological progress on the other side. I think in Europe we can and also we must achieve both, but I think with the right safeguards, it is not just necessary, but absolutely possible.
Isabel, actually, Marek, you have just provoked me to think about something which is, you kind of talked, here is, I think, Karolina as well. You're absolutely right. AI is just a technology that is actually being applied in all spheres of our lives, both commercial lives, life as citizens, employment, medical, education, everywhere, right? So I think we need to really be aware of where this is going and take this into, we can't just think, yet every time there's a new technology, we ask these kind of questions, what is the right thing? We really have to move on with the times. Today, we are still talking about use of data in AI, but actually tomorrow, or actually already this afternoon, we have got discussions on agentic AI. Everybody's telling us this is the next frontier. And so we have to move away from technology and how do we deal with that and a particular legal case and then take 3 years to do it. But just generally, how are we agile to adopt and adapt our existing principles to the new things that are going to come our way? Everything that we talk about is going to be even more pronounced with agentic AI.
Yeah, so I absolutely agree. And just to add, to build on what you just said, Bojana, the developments is so rapid. It's like it's changing every day, right? And now you're talking about agentic AI, and we are not even sure what comes next week, what kind of development, what kind of announcement. And so to stay on track, we really need to get back to the principles and to apply these principles to the new technological development. And I think the GDPR is, to a certain extent, has these principles, but they need to apply it in a proper way.
So now I can see Karolina on my screen. I'm very happy that you made it. I will shortly introduce you because I didn't do that when you weren't there. So I'm very, very happy that the panel is now complete. We didn't talk too much, just one introductory question, so you're completely fine. I'm very happy that Karolina Mojzesowicz is here with us today. She is Deputy Head of Unit for Data Protection at the European Commission. She played a key role in negotiating the GDPR and now oversees the implementation. With over 10 years of experience in the Commission's legal service, she has extensive experience in the EU competition. So thank you, Karolina, that you're here today. And I would give the word to you directly because, we just did a short introductory round, but maybe you can tell us, well, the GDPR is considered technologically neutral. And from your point of view, is this approach sufficient to cover AI systems, or does it need to be specifically adapted? What are your general views for this topic?
Isabel, thank you very much, and apologies for being late. The device not always doing what we want them to do. But, and building on what I've heard Bojana and Marek just said, GDPR is technologically neutral. It was designed in such a way in order to provide for a framework of processing of personal data, whatever the new technology will be. So that for once, we are not trotting behind the developments, but we are providing already for a framework, flexible one, which allows the technology to develop while protecting the fundamental right of data protection. And here Marek was just saying, and I fully agree, the core principles of the GDPR do apply. GDPR is principle-based, so lawfulness, fairness, transparency, purpose limitation, data minimization applies always, also in the AI world. Core rules, so this legal basis, lawful basis for processing, transparency obligations, data protection by design, by default applies. But nevertheless, the EU was of the opinion that certain elements or specificities in the AI world needs to be addressed through this product safety regulation and legislation as the AI, in order in particular to address questions of opacity, explainability of AI models, accountability, responsibility gaps, or maybe even questions of bias, fairness, not to speak about processing of non-personal data in the area of AI, which is obviously not addressed by the GDPR. And having said that, for example, areas where AI is not applicable, AI Act is not applicable, like as provided for in Article 2.6. So when we speak about scientific research and development, GDPR still does apply. So really this complementary role between the two sets of legislations, both being risk-based, with more specific rules in the AI Act and more flexibility in the GDPR.
Yeah, thank you very much, Karolina. Maybe Bojana, if you want to jump right onto that topic, maybe from a policy and also research perspective, where or does the GDPR has proven helpful, or what parts of it do you see that maybe need readjustment?
Yeah, and so we at CIPL have been actually looking at this intersection and interrelation between GDPR and AI technologies for some time, and all that work is actually culminated in our paper in December last year, just previewing and in advance of the EDPB's opinion on the same topic of how do data protection principles apply to GDPR. As you know, that was done at the request of the Irish DPA, and there were certain questions being asked. So in that paper, we looked at really what we identified early on as some tensions between the principles and the technologies that actually need to be resolved. Doesn't mean it doesn't work. It doesn't mean it's all bad, but what means is that regulators, policymakers, and organizations, right, Privacy Council and privacy officers have to consider how are we going to really apply these principles in practice. And just to say this, that we actually are doing some deeper now work and research on particularly sensitive data, use of sensitive data in AI. In fact, I'll be having a side event at the Global Privacy Assembly on this very topic next week. I think Marek is speaking there as well with some others. But anyway, so what have we found? Look, we looked kind of principle by principle, and starting from lawfulness and legal basis, the question is, what legal basis applies for use of first-party data and third-party data. So where a company has got its own data, or public sector organization wants to use data to train AI, what is the legal basis for that? And the same for third-party data, where their data comes from internet and other sources. And I think it's important to talk about both, because we can't stop innovation even with your own data. It is totally normal that organizations, and it'd be interesting to hear the automotive industry, are able to use their own data to actually create safer cars or more secure cars, right? Or to show where there is a problem so they can tweak the design so that people do not keep crashing always, by doing certain maneuver. So that was a question. And I must say that it was very helpful to see EDPB have this sort of more positive, progressive opinion, and really stretching the application of the principles and enabling legitimate interest, for example. Some of the other DPAs like CNIL, ICO, and you can see around the world as well, that's starting to permeate. So we are getting there, but there are some certain still legal uncertainties, maybe even lacuna, which is the use of sensitive data. Do we really have a legal basis because legitimate interest doesn't apply? Purpose limitation, data minimization, and that's maybe a myth. Data minimization does not mean we can't have personal data in the system. We can't use it. Data minimization does not mean have the least possible data. No, it means have the data which is relevant, appropriate for the purpose. Well, if the purpose is training algorithm with diverse data sets that include different languages, different backgrounds, well, then we need that data, right? So the data minimization necessity tests are fulfilled. So it's not changing the principle, it's changing the mindset and the purpose limitation as well. If I have a data for one purpose I want to use for something else, which is training and development, and there is no risk and harm, and I conduct risk assessments, and I comply with the rest of the law. In fact, probably 6.4 article would allow for that. So things like that. I have to mention individuals' rights because I think that's going to be tricky, and we will have to see this on a case-by-case basis. For example, today research on machine unlearning is limited. It's difficult. If I sort of say, I don't want my data in the data set, it's very difficult for the provider of the system, but even deploy it, to take away my information and then retrain that set without me. And I do want to be provocative a little bit and to sort of say, to Marek's point, Karolina, this is something we kind of started with. Data protection is a fundamental right, super important. But there are other rights, there are other societal benefits. Do I really have a right, for example, to exclude my important health data set out of the overall R&D and use of data for medical research and diagnostic, if that's going to help the society and everybody else? And of course, it's done responsibly in compliance with the law. So I think, the question of individuals' control, if you like, or rights is going to be kind of brought into focus, sharp focus. Maybe lastly, automated decision-making. I think we're going to have to do some thinking there as well. Obviously, we have these provisions in GDPR. They are truly meant to apply to significant decisions made by solely automated systems. That's subject to consent today and legal obligation. As you know, UK is going a little bit further, allowing that, not with sensitive data, but allowing it subject to redress in the rights of individuals. So I kind of feel there are some really important conversations that we need to have with the help of the Commission, that is able, the guardian, if you like, of the laws, with the help of DPAs who are also grappling with these things, but also organizations who are sort of saying, here is really what happens in reality. And just to repeat this, legal certainty is hugely important. If we are grappling with these questions and we all together have got, 50 years of data protection experience, how does an SME, a startup in Europe that wants to scale, wants to use data, wants to do something, and there are lots of these that we keep meeting all the time, how are they going to kind of find that sort of information and that legal comfort that they can do this, they can use the data, they can move forward? So I'll stop there, but we can sort of take some of these maybe in the conversation further.
Yeah, perfect. Thank you very much. I will get back to Karolina in a minute, but just Marek, maybe from an industry experience, what challenges in general, maybe a general question first, do you see at Volkswagen? What is important for you? And maybe you can refer to the one or the other point that Bojana just made.
Yeah. So first of all, I can also again echo what Bojana just said, and I find these papers really, really helpful, and the work specifically that CIPL is doing. And having said that, I mean, AI is a quite broad concept, right? And we at Volkswagen focusing on building AI systems and AI applications. So we are integrating proven, general purpose AI models rather than building our own large language models, for example, from scratch. So we have like a specific perspective on AI compliance, privacy compliance. But because AI, and Bojana, you said it very nicely at the very beginning, relies on data at every stage, right? Privacy goes straight to the core of how product teams at Volkswagen design and train AI. And there's like this fear of getting it wrong that can slow down innovation. And so the friction is maybe about turning this proportionality, what I was talking about at the very beginning, into engineering and process. I can talk about this also later if there is still time. And to double down on this uncertainty. So across product teams, there is often confusion about what kind of data they can lawfully process. And this is, as you all know, far from trivial, right? I mean, look at the recent court rulings about what counts as personal data. So it's a complicated questions. And there are questions about, can we anonymize and still achieve reliable results? Can we use synthetic data and still reach the same level of performance, the same level of security, safety? And these questions create hesitations. And that is why we need these like clear risk-based guidance. This is so important, right? And we need to do a lot of explanations, guidance, internal consultations around these questions. And this is specifically true also for Article 9 data. Bojana, you mentioned the event at GPA next week. And this is, and a narrow interpretation of the GDPR creates, I would say, like even like a dangerous paradox, right? These rules are designed to protect individuals. And this could prevent, on the other hand, innovators from taking the necessary steps by training algorithms, for example, to ensure AI systems are safe, accurate, and fair for these people. And this is exactly when it comes to processing such data, for example, autonomous driving.
Karolina, if we now maybe take a short look at accountability, what lessons can be drawn from the GDPR accountability mechanisms for future AI governance?
Well, I would first of all agree with what was said. I mean, GDPR is flexible, principle-based regulation, which allows for adjustments, which provides for adjustment, not only allows for adjustments of the safeguards dependent on the risks. And here I'm to your question, the accountability. Yes, well, the very broadly captured by AI Act entities engaged in the process of development, putting on the market and using AI systems and then / controls processors from the GDPR world, to the extent personal data is processed, will need to comply with this principle of accountability. A banality, really, what I'm saying, by matching the safeguards with the risks the processing will constitute of the personal data will constitute for the data subjects. Concrete lessons learned is be cautious, but there are only very few instances, in particular in the AI Act, when artificial intelligence is prohibited. And this broad accountability and flexible accountability assessment under the GDPR is matched with more concrete guidelines and a more spelled out risk-based approach from the AI Act. So I think I think it's a more concrete accountability setting for entities engaged in AI Act when complying with the GDPR, because they can get guidance already from the AI Act and the risk settings and the safeguards provided in there. I think that one can, interpreting the two complementary pieces of legislation, this can help.
Yeah, thank you very much. Bojana, would you agree? Or maybe I thought about, we wanted to take a short look at privacy enhancing technologies.
Yes.
Maybe we can swing around.
No, totally. So I do agree. Look, I think actually we are more mature on data protection accountability than we are on AI, but I think AI accountability is catching up, and we can certainly learn a lot from what we have done in accountability and the GDPR. As you know, CIPL has been promoting the accountability framework, which has got the 6 essential elements, and companies who are doing that are going to be very ready for AI. And there are going to be lots of touch points, right? The fairness exists in both laws. Data protection impact assessment, AI impact assessment, understanding of risk, absolutely, but also about benefits. It's what Marek was saying, risk-based approach, meaning where are there risks, we will address them, but also what are the benefits of that processing, and so that we understand both. So ADM in both laws. So I think there are lots of touch points, a lot that we can learn from what privacy teams have done, but also take this forward, right? Because there are new processes and new controls, like red teaming, for example, right? And then let's talk about pets. So pets, to me, is part of accountability. You can't just deliver accountability through what I call rules, schools, and tools. You need technologies as well. And the technologies are about how do you deploy privacy preserving. That, I think, better word is privacy preserving technologies in different stages of AI lifecycle. We have done paper. I'm sorry, CIPL has seemed to have a paper about on everything. But anyway, we have actually looked at pets, and specifically pets in AI, and looked at the use of pets in all the vertical sort of, the life stage of development, from sourcing data to model training to model deployment, model updates, and then of course security, and looked at sort of anything from synthetic data, federated learning, multi-party computation. But please have a look. It's very technical, but the short answer is these technologies do work. They are not a panacea. They're not absolute. There are things they can deliver, but you can't always use synthetic data, for example, because you cannot then get the viability of data that you need. But they are useful depending on a particular case study. They require lots of investment. They can't be the pursuit only of the biggest tech companies, right? We need to push this down the chain so that everybody is able to use them, and everybody sort of starts building these and deploying them. You can't just buy them off the shelf. You really have to think very carefully which particular technology works. But the good thing about them is that they don't just deliver privacy protection, security protection. They also enable you to use data. If you're a company that really wants to use data, but also protect this important asset, then the privacy preserving technologies work very well. Final point, because hopefully we have some regulators here, Karolina is here also, we need regulators and lawmakers to incentivize the use of pets, right? We need more legal certainty to say, yes, these pets actually deliver a particular result and they're good enough, right? In light of the European Court of Justice ruling, this data is considered pseudonymous data. Go ahead, fine, this is good enough, right? So if we look for perfection, we're going to hurt innovation. So we need to just that kind of encouragement and push by regulators.
Yeah, as always, we're already running out of time. We could discuss for more hours, but I just want to, Marek, one last point maybe. If we look at one other perspective or one another, point regarding the supervisory landscape in Germany and Europe, maybe you can give us a short, very short view. What do you think about that?
Right. So I think what we need is really that, supervisors need to self-commit to proportionality and to weigh in innovation and competitiveness alongside privacy. It has to be consistent with the treaties, of course, right? But it has to weigh in. And what we need to apply the European Union's principles of good administration to DPAs and also the European Data Protection Board, right? We need clear reasoning, predictable timelines, fair process. We would love a wide and systematic stakeholder participation, right? Transparent assessment of comments. similar to what we see in international standardizations organizations and bodies, right? And it doesn't mean that industry should have a vote on regulatory decisions, right? Don't get me wrong, but it does mean that regulators should not forgo the expertise that we have, companies, engineers, practitioners, and listening systematically to those who build and operate AI. I think that would improve the quality and also the feasibility of the guidance, right?
Yeah.
Also, I think like the risk-based approach was mentioned many times, and I think this is something that Europe should really double down on. Think of codifying a clear risk principle, privileging some privacy-enhancing technologies, rebalancing obligations that create more red tape or bureaucracy than actually reducing risk. And I think it makes it more enforceable and credible. And I think because we have Karolina here, I think last but not least, that when I think about GDPR reform, I think we should think about giving the European Commission also a stronger role through, for example, delegated implementing acts, specifically when it comes to privacy standards and provide operational clarity. I also think we touched on AI Act, but still it could take a stronger coordinating role across the digital regulatory stack, GDPR, DSA, AI Act, Data Act, and what's coming. And I think this would create the same baseline for everyone in Europe and provide this legal certainty that would definitely lead. So if companies like us, we can focus on building safe and innovative products.
Yeah, thank you very much, Marek. Our time has already run out, but Karolina, maybe one last question for each of you in one sentence. We've got time for that. If you had to formulate one sentence, what is the most important step from your point of view to ensure that data protection, GDPR, and AI or AI Act go hand in hand in Europe in the future? Karolina, maybe you first.
I will be the last, I think. I have to think about it.
Okay, no problem. Then maybe Bojana.
Well, why did I say? I think we need to sort of have a change of mindset in everybody in Europe, from regulators to policy lawmakers, and of course, data protection officers as well. Data is essential for AI and for innovation and development. And we can't just think about one fundamental right. We have to think about multiple fundamental rights to life and education and health and all the benefits that AI brings. So that would be my message. Think in a different way.
Thank you, Marek.
Yeah, I agree. I think we really must recognize that the key is not choosing between privacy on the one hand and innovation on the other hand, but we need to ensure that the GDPR's principles, proportionality, risk-based approach are applied consistently, and so both can advance together. I think this would be my wish for the future.
Thank you. So, Karolina, you get the last word.
Well, I don't think I will be much different than what my Bojana and Marek said. I think, and this is what the Commission was always saying, enforcement which balances between the fundamental rights in line with the recital 4 of the GDPR, which allows to capture risks we as a society don't want to, don't want to run into, but which allows also to embrace the development and of the technology in a wise and responsible way.
Perfect. Thank you very much. That's a very nice last word. Thank you for taking the time. And I hope you have a good afternoon. And I hope we can continue our discussion at some point, maybe even in person. Thank you very much.
I hope so. Thank you very much.
Thank you.
Thank you so much.
Thank you. Bye-bye.
Bye-bye.